Robert Olson had 29 days to decide what to put in writing. On October 9, 2001, Chiquita Brands International's general counsel finished an internal memo about the company's Colombian banana unit, Banadex. His message was simple and unambiguous. Banadex had been paying Colombia's AUC paramilitary group for years, but the US State Department had just designated the AUC a foreign terrorist organization, and continuing the payments now meant something new. It meant a federal crime. The Department of Justice later summarized Olson's warning in Chiquita's March 2007 plea agreement. Continuing the payments after the September 10th designation would expose the company and the executives who approved the transfers to prosecution under 18 U.S.C. Section 2339B. The plea agreement preserves the heart of Olson's warning in stark, prosecutable language. Continued payments would constitute knowing provision of material support to a designated FTO, in violation of 18 U.S.C. Section 2339B.
Olson's memo did not arrive in a vacuum. The DOJ's account describes earlier internal concern about the legality and optics of paying an armed group. The designation changed the compliance problem into a federal crime problem. After September 10th, the question was no longer whether the payments looked corrupt, but whether executives were authorizing a felony. The November 2001 board decision, stop or keep going. The DOJ says the board received Olson's analysis at a November 2001 meeting and authorized the payments to continue anyway. The plea documents identify the board's chair in that deliberation as Cyrus Friedheim Jr. The decision did not end the transfers, it ratified them. Chiquita's later public explanation hinged on employee safety, the claim that refusing would endanger workers in Colombia. The DOJ's criminal case did not adopt that framing.
And the record that matters here is not what the company said in 2007 on television or in congressional testimony, but what it did after getting a written warning that payments to the AUC were illegal. Strip away the legal language and the sequence is simple: a warning, a vote, and 26 months of payments that outlived both. Had Chiquita spent that window building a documented exit, notifying Colombian or US authorities, suspending cash transfers, withdrawing managers, those steps would now be the centerpiece of its defense. Instead, the paper trail runs the other way. The payments continued, and after the designation, the company adopted methods that made them harder to trace. That choice is inseparable from the place where the money was made, Urabá, Colombia, a banana corridor where labor organizing and land ownership were policed at gunpoint. Urabá sits where the Atrato River Basin meets the Caribbean, flat, fertile lowlands bordered by jungle and mangrove.
United Fruit Company engineers began building there in the early 20th century for three reasons that still govern the region's political economy: alluvial soil suitable for monoculture, access to export routes through turbo, and a labor market with few alternatives in the surrounding departments. By the late 1980s, Chiquita, United Fruit's corporate successor after its 1984 reorganization, had inherited the infrastructure, and Banadex controlled roughly 15,000 hectares of plantations across Urabá, plus a separate growing corridor near Santa Marta on the Caribbean coast. Labor conditions: violations, subcontracting, and a body count. Human Rights Watch's 2000 report, The Ties That Bind, describes how large banana operations in Urabá relied on subcontracting structures designed to shield plantation owners from labor law liability. HRW's documentation also tied working conditions to a larger pattern. Colombian labor inspectors repeatedly recorded wage and benefits violations, while union activity was met with lethal force. Sintrenagro, the main agricultural workers' union in the region, became a target class. HRW reported that by the late 1990s, Urabá was among the most dangerous places on earth to be a labor organizer. The violence didn't only punish specific leaders, it changed what workers believed they could ask for and what they thought would happen if they tried. Armed control as labor policy. By the mid-1990s, the AUC had established operational dominance in the banana zone through violence aimed at two sets of enemies at once: guerrillas, FARC and ELN, who extorted and taxed agriculture, and civilians accused, often on thin or fabricated grounds, of supporting them. HRW's 2003 report, You'll Learn Not to Cry, documented AUC recruitment in Urabá that fed on displacement and trauma, pulling children from communities that had already survived massacres. The result was a closed loop. Massacres and threats produced displacement, displacement produced poverty, poverty produced recruitment, recruitment sustained armed control. That machinery also reshaped the labor market. As communities associated with union activity were killed off, dispersed, or terrorized into silence, wage pressure dropped. Subcontracting and fear did the same job. They separated the people who cut and packed the fruit from the people who could be sued for what happened to them. The AUC did not arrive in Urabá as an abstract terror brand. It arrived through a specific unit and a commander whose business interests overlapped with the region's agricultural consolidation. The AUC unit most associated with Urabá was the Bloque Bananero, commanded by Raúl Hasbún, alias Pedro Bonito. Hasbún was not a career soldier. He was a banana rancher and regional businessman who later described the guerrilla presence as an existential threat to agriculture and to his own holdings. In Justicia y Paz proceedings, his account framed the bloc's purpose as restoring order, a term that, in the banana zone, routinely meant forced compliance. Suppress guerrilla taxation, neutralize unions, and eliminate resistance to land control. The Bloque Bananero's violence operated alongside a protection economy. Banana producers paid, the AUC enforced. What Chiquita's leadership knew, and when the DOJ's plea agreement is unusually explicit about the company's internal chain of knowledge, Banadex made recurring payments to the AUC. The AUC was designated an FTO on September 10, 2001. Chiquita's general counsel put the legal risk in writing on October 9, 2001, warning executives the payments violated Section 2339B. The board discussed the memo in November 2001 and authorized the payments to continue. The fight in later litigation has not been over whether the memo existed. It has been over what it should mean in court. A corporation was told, in writing, that the payments were a felony, and kept paying. Money, small transfers, protected margins. The payments totaled $1.7 million over roughly 7 years, a line item small enough to be dismissed as trivial against Chiquita's global revenue, but large enough to matter to an armed group operating locally. The bigger number was the one the company did not pay to workers. Civil filings and public financial reporting describe Banadex as one of Chiquita's most profitable banana operations by the early 2000s. A key internal comparison cited in the litigation: production costs in Urabá ran dramatically lower than in Central America, a differential plaintiffs linked to the collapse of effective union activity in the very years the AUC was killing union numbers and organizers. The post-designation shift that prosecutors did not ignore. After the FTO designation, the DOJ says Chiquita changed how the money moved. In the Santa Marta corridor, transfers shifted away from traceable channels toward cash deliveries. That detail matters because it speaks to intent. A company paying purely under coercion has incentives to build an evidentiary record, to notify authorities, to memorialize threats, to stop once a safe exit exists. Engineering less traceable delivery after a written warning of criminal exposure points the other way. Not entrapment, not confusion, but operational adaptation. Fernando Aguirre became CEO in January 2004. The final payment occurred in February 2004. In later public appearances, including congressional testimony tied to the 2007 plea, Aguirre presented the payments as extortion made to protect employees. The plea agreement's language is colder and more prosecutorial. It treats the transfers as knowing support to an FTO, not as duress excusing criminal conduct. The question the civil cases forced into open court was narrower and harder. What did that money buy in Urabá during the 26 months after the board was told the payments were a crime? Between 2011 and 2012, Raúl Hasbún testified in Colombia's Justicia y Paz process, the transitional justice system created under Law 975 of 2005, offering reduced sentences in exchange for demobilization and confessions. Hasbún described a protection finance structure calibrated to plantation size. Producers paid, the bloc maintained territorial control, the money funded weapons, salaries, informant networks, and command infrastructure. He also confirmed what the US criminal case had already made unavoidable. Banadex was among the contributors. One of the most revealing words in Hasbún's account was order, a euphemism that, in the banana zone, often meant a disciplined program of public killing designed to be seen. Violence as message, not collateral. Reported portions of Hassman's testimony describe a targeting process built from informants embedded in plantation life. People who knew who attended meetings, who complained about pay, who spoke to whom, who could be painted as guerrilla. The end stage was frequently nighttime visits, executions, and bodies placed where other workers would inevitably encounter them. Plantation roads, bus stations, the entrances to worker compounds. The signal was part of the method. Land and displacement, the other ledger. Colombian jurisprudence developed later, particularly under the Victims and Land Restitution Law, Law 1448 of 2011, describes the broader pattern across Urabá and neighboring departments. Paramilitary violence driving displacement, and displacement enabling land consolidation into larger agricultural holdings, including banana production. The best-known massacre in the broader region during the period was El Haro, October 1997, in Ituango, Antioquia. Roughly 15 civilians killed, hundreds displaced, the village destroyed. El Haro is tied to a different AUC structure than the Bloque Bananero, but it illustrates the point the Banana Zone learned repeatedly. This violence was not only about combatants. It was a tool for remaking the countryside. Union killings, a documented sequence. HRW's The Ties That Bind reported at least 60 union members killed in the Banana Zone in the years preceding 2000.
Academic and policy analyses drawing on Colombian police statistics show municipalities at the heart of banana production. Apartado, Turbo, Carepa, Chigorodo, posting homicide rates in the late 1990s and early 2000s among the country's highest. Those numbers are the backdrop to the US civil cases, but the claims that reached a jury in June 2024 were not built on statistics. They were built on named, dead, and family testimony. A bellwether set selected to test whether a Cincinnati funding decision could be treated as legally relevant to specific killings in Colombia. The Southern District of Florida litigation spans thousands of claims. The June 2024 bellwether trial in West Palm Beach took 9 representative killings, selected to test causation and the plaintiff's aiding and abetting theory across different victim profiles inside the banana economy.
Public reporting by The Guardian, The Associated Press, and Colombian outlet El Colombiano, along with the publicly filed complaints, makes 3 of those 9 cases particularly legible, because they map directly onto the AUC's 3 most common leverage points in Urabá: labor, land, and transportation. Manuel Antonio Romero Tulcan, a union-linked killing in Turbo, 2001. Romero Tulcan worked in the Banana Zone and belonged to Sintra y Negro, according to the civil complaint. He was killed in 2001 when AUC fighters came to his home in the early morning hours. In filings, his widow, identified by initials for safety, described the aftermath in practical terms rather than rhetorical ones. Income gone, forced relocation, and no realistic path to justice at the time because local authorities were infiltrated, intimidated, or both. This is the labor control case in miniature. A union member dies, the family moves, organizing becomes irrational.
How the law hooked to the person. Romero Tulcan's case became one way to test the post-killable theory that corporate decisions made in the US, including the post-designation continuation authorized by the board, touch and concern US territory enough to proceed under the ATS, even though the killing occurred in Colombia. Edilberto Alzate, Land Refusal Followed by Murder, 2002. Alzate was not alleged to be a union member. The complaint frames him as a smallholder whose land bordered a banana plantation. After refusing repeated approaches to sell, he was killed in 2002 by AUC fighters, his son later testified. The surviving family was ordered to vacate within 48 hours. The land was later acquired, the complaint alleges, by an entity that supplied bananas to Banadex. This case ties violence to land consolidation, the same mechanism Colombia's land restitution jurisprudence later tried to unwind. Armed displacement clearing the way for agricultural control.
How the law hooked to the person. For Alzate's estate, the legal fight is not only about whether Chiquita funded the AUC, but whether that funding can be treated as practical assistance that foreseeably enabled the coercive environment in which land seizures occurred. Angel Año, a checkpoint execution in the Santa Marta corridor, 2003. Año was a bus driver, the complaint and Justicia y Paz records state. He was killed in 2003 at an AUC checkpoint while transporting workers. His family's position, described in filings, is that the AUC accused him of contact with FARC, a charge that could attach to ordinary life in contested territory, where accidental or unavoidable contact with armed actors was often treated as collaboration. The Associated Press reported that Año's widow traveled to the federal courthouse in West Palm Beach for the verdict, after waiting 17 years for a U.S. courtroom to hear the case. How the law hooked the person. Año's killing also tested one of the plaintiff's key theories about the Santa Marta corridor. After the FTO designation, the company shifted payment methods there toward cash, a factual detail plaintiffs used to argue knowledge plus continued support, rather than coerced victimhood. The 6 other bellwethers, what the public record shows without collapsing into caricature. Court filings and contemporaneous reporting describe the remaining 6 bellwether cases as spanning the same control architecture the AUC used across the banana economy: workplace, transport corridors, and rural land, without requiring every victim to fit a single stereotype: union leader, guerrilla, or bystander. In the bellwether set, jurors heard variations on a small number of recurring mechanics: armed men arriving at homes at night or pre-dawn hours, killings at roadside or checkpoint stops tied to territorial control, threats that forced families to leave within days, an environment where reporting to authorities carried its own risk. What changed from case to case was the alleged trigger: labor activity, land refusal, presence in a contested corridor, or accusation by an informant network embedded in plantation communities. The verdict. The jury found Chiquita liable in 8 of 9 bellwether cases and awarded $38.3 million in damages. Post-verdict reporting described the single defense win as turning on a disputed factual question about responsibility for a particular death, not on a global rejection of the payments as aiding theory. This was not the end of the litigation. It was the first time a U.S. jury treated a payment record, the memo, the board authorization, the continuation after designation, and the delivery methods, as legally meaningful to real names and real families. That outcome was far from inevitable. For years, the Supreme Court has been tightening the legal channel the plaintiffs used to get into U.S. court at all. The civil cases leaned on 2 overlapping frameworks: the Alien Tort Statute, ATS, and, in parallel, claims under the Torture Victim Protection Act, TVPA, against individuals. Both routes have been narrowed by Supreme Court doctrine over the last decade. ATS. From Filartiga to the post-2013 constriction. The ATS is a 1789 statute revived in modern human rights litigation by Filartiga versus Peña-Irala, Second Circuit 1980, which allowed foreign plaintiffs to sue in U.S. court for violations of international law. Over time, plaintiffs used it against corporate defendants tied to overseas abuses. Chiquita cases filed starting in 2008 argue that funding the AUC amounted to aiding and abetting violations of customary international law, including extrajudicial killing and crimes against humanity. Then came the bottleneck decisions. Kiobel versus Royal Dutch Petroleum 2013 imposed a presumption against extraterritoriality. ATS claims based on foreign conduct must touch and concern the U.S. with sufficient force. Jesner versus Arab Bank 2018 barred ATS suits against foreign corporations. Chiquita, a U.S. corporation, sits on the other side of that line. Nestle USA Inc. versus Doe 2021 held that general corporate activity in the U.S. is not enough if the conduct relevant to the ATS's focus occurred abroad. Plaintiffs must allege more than domestic decision-making untethered to the actionable conduct. Judge Mara's rulings. Cincinnati as the locus of the actionable conduct. Chiquita argued that the relevant conduct occurred in Colombia through a Colombian subsidiary. Judge Kenneth Mara rejected dismissal in a 2014 ruling that became the hinge of the case. The court treated the authorization and governance of the payments as domestic conduct, the board decision, the post-designation continuation after a written felony warning, and the company's payment protocols. That framing matters under Kiobel and even under Nestle. The argument is not a U.S. company had meetings, but a U.S. company from U.S. headquarters authorized payments to a designated FTO after being warned it was a federal crime. The locus of decision-making became part of the conduct, not merely a corporate background detail.
In a 2016 ruling, Judge Mara also sustained the aiding and abetting theory at the pleading stage, pointing to the knowledge record, Olson's memo, the board's continued authorization, and the shift to less traceable payment methods.
Those facts were sufficient, the court held, for a jury to find practical assistance provided with knowledge that it would contribute to the AUC's pattern of violence. Interweaving the doctrine with the people. For Romero Tulcan's family, Kyobel and Nestle became fights over whether the Cincinnati boardroom decision is legally part of the wrongful conduct, not an abstract U.S. nexus. For Angel Año's estate, the Santa Marta cash delivery protocol became evidence used to argue knowledge plus continued assistance after the designation, a factual bridge between U.S. authorization and Colombian execution. TVPA, the individual defendant constraint. The TVPA route is narrower by design. The Supreme Court's decision in Mohammed versus Palestinian Authority, 2012, held the TVPA applies to natural persons, not organizations. That constraint shaped the Chiquita litigation. TVPA theories required naming individuals and tying them personally to torture or extrajudicial killing, not simply to corporate approval of criminal payments. The result is a split-screen accountability problem. The corporation pleaded guilty in 2007. Civil jurors in 2024 assessed corporate liability and wrongful death claims. And yet the path to naming and punishing individuals has remained steep, legally and politically, even when a memo put criminal knowledge in writing. Chiquita's March 2007 plea resolved corporate criminal liability. The company admitted it made illegal payments to the AUC and agreed to pay a $25 million criminal fine. No individual executive was charged. The gap has been a lasting point of contention because the criminal case contains unusually clear markers of knowledge and authorization: a general counsel memo warning of a felony, a board discussion, continued payments, and post-designation payment adaptations. Congressional scrutiny: brief, then gone. In 2007, the House Judiciary Committee's Subcommittee on Crime, Terrorism, and Homeland Security held a hearing probing the case. DOJ witnesses emphasized corporate cooperation. Chiquita voluntarily disclosed the payment record, and declined to provide a detailed public account of individual liability decisions, pointing to investigative sensitivities. The principles the public record keeps returning to Robert Olson. As general counsel, he authored the October 9, 2001 memo warning continued payments would violate Section 2339B. He did not become a criminal defendant. Cyrus Friedheim Jr., identified in the DOJ account as chairing the board deliberation where continuation was authorized. He did not become a criminal defendant. Fernando Aguirre became CEO in January 2004, became the public face of the extortion narrative during the 2007 plea era. The last payment occurred in February 2004. In broader debates about corporate crime, scholars have pointed to the Chiquita case as a familiar American trade. Resolve the case through a corporate plea and fine, reward cooperation, leave individual accountability to a theoretical, ongoing investigation that never reaches charges. By the time civil juries began hearing bellwether deaths in Florida, the statute of limitations window for prosecuting individuals for the early 2000s payment period had long since narrowed. The civil litigation and the June 2024 verdict is where the factual record has had its most consequential test. That verdict now sits inside a complicated financial structure, a company taken private, owned by a banking family, and still facing thousands of unresolved claims. The bellwether verdict awarded $38.3 million across 8 wrongful death findings. Plaintiffs' attorneys have said thousands of claims remain pending in the Southern District of Florida and related proceedings, tied to AUC operations in the Banana Zone during the years Banadex was paying. Colombia's transitional justice machinery continues to generate evidence. The Special Jurisdiction for Peace, JEP, created under the 2016 peace accords with the FARC, has produced extensive records on violence in Urabá. Plaintiffs have sought to use those materials to corroborate patterns of AUC operations and command responsibility in the period the payments covered. Damages math and the temptation to extrapolate. If one mechanically applies the bellwether average, roughly $4.8 million per victim, across even a portion of the docket, the exposure can climb quickly into the hundreds of millions. But bellwethers are not a census, they are test cases.
The real issue is what survives appeal: the evidentiary rulings, the causation standard, and the legal theory connecting corporate support for an FTO to specific killings. A private company, a new owner, and old liabilities. In 2015, Chiquita was acquired by the Safra Group, controlled by the family of banker Joseph Safra, in a leveraged transaction that took the company private and ended its SEC reporting obligations. Analysts and litigants have pointed to indemnification and transaction structure questions raised in Delaware takeover litigation materials, whether the post-acquisition ownership bears financial responsibility for judgments tied to pre-acquisition conduct, or whether the deal architecture functions, intentionally or not, as a liability firewall. The next phase is narrower and more technical. Which parts of that sequence appellate courts treat as legally sufficient to link a Cincinnati authorization to a Colombian death, and which parts they sever?
What is now fixed is the public sequence that jurors found actionable. After the AUC's FTO designation, Chiquita's lawyers warned in writing that continued payments would violate Section 2339B. The board authorized continuation, payment protocols became less traceable, and the money continued flowing for 26 months after the felony warning, while the AUC's Banana Zone units killed civilians in patterns documented across Colombian proceedings and human rights reporting. For Angel Año's widow, none of that legal architecture was abstract. She waited 17 years for a courtroom to say his name. The verdict did not undo the wait, but it put on the record for the first time that a corporate decision made in Cincinnati and a death at a checkpoint in Colombia could be spoken about in the same sentence, under oath, in front of a jury.